Perfect. Great. Well, again, thank you for joining us for today for this Lunch and Learn from San Diego North EDC. I am Eric Rufold. I'm the CEO. We hope to be back in person at the end of February, if not then for sure by the end of March. But as people know, we're still dealing with COVID and the aftermath. So we were excited to be able to bring this to you via Zoom and a virtual. We thought it was important to kick off our 2022 with a human resource law or employment law update. Many of the employers and small businesses in North County are making adjustments and trying to navigate through the world. And so we were excited to do that. And we were especially excited to be joined today by our issue expert, Jenna Layton-Jones. She came to us through a referral from one of our investors, Blake Law Firm, and so we're excited to host Jenna today on the webinar. Jenna's an experienced employment law attorney and trusted business advisor. She is a frequent speaker at human resource seminars, a alum of UC Berkeley and University of San Diego Law School, where she has a JD. Prior to founding her own firm of Layton-Jones Law, she was a partner at another Southern California law firm where she spent over a decade providing employment law advice and litigation defense to both large and small companies throughout the state. So we are excited to hear from Jenna today. And with that, she will take it from here. And again, if you have any questions, please put them in chat. And that's how we'll handle Q&A at the end of the webinar.
Awesome. Thank you so much for the nice introduction, Eric. Thank you all for being here. It's always my great pleasure to present at these types of seminars. I love sharing information. And obviously, as most of you know, either being HR consultants or being employers in California, there is always lots of new news on the California employment law front. The good news today is that although obviously we've all been dealing with a lot in terms of COVID, and we'll get to the COVID updates at the end of the presentation, it was a relatively light non-COVID legislative year, meaning there wasn't a lot of new legislation pertaining to non-COVID issues. So that is often a welcome reprieve, I know, for California employers. That said, there are still a handful of generally applicable new laws and changes that you should be aware of. So let's go ahead and go through those. And then, like I said, we'll talk about all of the COVID stuff at the end, because I'm sure there are questions on that. Let me share my screen with you. Can you see my screen?
Not yet, Jenna.
Not yet. Okay. Let me see if I can. Where am I here? Share screen. Entire screen. Share. What am I doing wrong here? Play.
And Jenna, I can pull your slides up if you need me to. And then,
I may need that, Eric.
all right.
Sorry
Okay, so let me do it on my end, and I will go ahead and there and back here, and I'll share screen. Screen and share. And do we have up your presentation? I believe we do. And let me do one thing here, slideshow, and from the beginning. And all right, Amanda, can we see the slides now on the screen?
Yes, we can see them.
Perfect, excellent.
Perfect. Thanks, Eric. Sorry about that. So let's start with the California minimum wage increase. As most of you are probably aware, minimum wage in California went up as of January 1st. So California's state minimum wage for companies with 26 or more employees is currently $15 an hour. The state minimum wage for companies with 25 or fewer employees is $14 per hour. But you also need to be aware of local minimum wages, that's city or county minimum wages that may be above the state numbers. So for example, if you have employees working within the city of San Diego, again, that's city, not county, city of San Diego employees must be paid at least $15 an hour. The city's minimum wage is $15 an hour for all employers, regardless of employer size. All right, so make sure you're aware of the local ordinances. Now, because the state minimum wage has increased, we also have increases to the salary thresholds for the white collar exempt classifications, which are tied to the state minimum wage. So as of January 1st of this year, the salary threshold for the executive, administrative, and professional exemptions is $62,400 annually for employers with 26 or more employees. And the salary threshold for the exemptions for employers with 25 or fewer employees is now $58,240. And remember, if an employee does not meet these salary thresholds, then they cannot legally be classified as exempt. And you should also remember that even if they do meet the salary thresholds, they still also have to meet the duties test in order to be legally and properly classified as exempt. And if you have no idea what I'm talking about when I say the duties test, let's touch base offline. Employee misclassification continues to be a major issue and risk for many employers, and it's important to make sure that you are properly classifying your employees as either exempt or non-exempt in order to avoid potential risk and the potential for significant liability down the road. Okay, and last but not least on this subject, the salary threshold for the computer professional exemption has increased. So as of January 1st of this year, computer software employees must be earning at least $104,149.81 per year, or $50 an hour, to qualify for the computer professional exemption. So best practice tip here is just review your payroll practices and your employee classifications and make any necessary adjustments ASAP. Moving on to the California Family Rights Act, or CFRA. Just quick reminder, most of you are already aware that the CFRA is the California law that provides up to 12 weeks of job protected leave, unpaid job protected leave for certain qualifying employees for certain purposes. And as most of you are aware, we got really significant expansion of the CFRA at the beginning of last year. And just to quickly review, at the beginning of 2021, the CFRA was expanded to apply to all California employers with 5 or more employees. So that was a big change, dropping down from the previous threshold of 50 employees. The changes to the CFRA also expanded the list of individuals for whom an employee could take a leave of absence to care for. It expanded the definition of child. It added a new reason for taking CFRA leave, which was a qualifying military exigency, and it eliminated a couple of previous exemptions. So the CFRA has been tweaked again slightly for 2022. Luckily, it's a fairly minor change, and the law just now clarifies that parent-in-law is included in the list of family members for whom an employee may take leave to care for. So in other words, if an employee has a parent-in-law with a serious health condition, the employee may be entitled to take up to 12 weeks of job protected CFRA leave to care for that individual. And it's important to note that this little change could potentially result in an employee being entitled, or at least arguing that they're entitled, to take more than 12 weeks of leave. For example, they could take 12 weeks of job protected CFRA leave to care for a parent-in-law, and then argue that they're entitled to an additional 12 weeks of leave under the federal FMLA if the employer has 50 or more employees, because parent-in-law is not included as a covered person under the federal FMLA as a person that the employee could take leave to care for. So you could get an argument that, well, you know, I didn't exhaust my FMLA leave with my CFRA because parent-in-law is not covered under FMLA. So that's just something to be aware of. I don't anticipate it being a huge issue, but it could come up. Employer best practice tip in this area, if you haven't already done so, make sure your employee handbooks are updated with all of the CFRA changes that we've seen over the past year, especially with all the changes that went into effect last year, because those were pretty major. So if you're a smaller employer with fewer than 50 employees, you will have had to add the CFRA policy to your handbook. And even if you're a larger employee who was previously having to comply with CIFRA, you still probably need to tweak your policy a little bit to make sure that it is updated to comply with all the new changes we've seen over the last year. And I'm still seeing a lot of employee handbooks that either are not, their CIFRA policy has not been updated, or in the case of smaller employers, it doesn't even reflect a CIFRA policy. And again, if you're an employer with 5 or more employees, this law now does apply to you. And I think that this is another significant area of liability for employers, especially in the COVID era, when we have lots of employees who are taking leaves of absence, who are dealing with serious, COVID-related health issues. So again, just make sure you're updated and up to speed here. Let's change gears and talk about confidentiality and non-disparagement provisions in settlement and severance agreements. I'm sure that nobody will be surprised to learn that despite everything else going on in the world for the last 2 years, the Me Too movement is really still alive and well and is still a focus of legislative action here in California. So this year we got a new law that impacts confidentiality and non-disparagement provisions in settlement and severance agreements. Entitled the Silence No More Act, the new law expands upon 2 recent California laws aimed at ending so-called secret settlements, which many people believe allow unlawful conduct to continue in the workplace. So back in 2018, California enacted a law that precluded settlement agreements from restricting the disclosure of factual information relating to claims of workplace harassment or discrimination based on sex. The new law for 2022 expands this prohibition on settlement agreement confidentiality provisions to include all types of workplace harassment and discrimination precluded by the Fair Employment and Housing Act. So in other words, it's no longer legal for settlement agreements to preclude employees from disclosing the factual basis for claims based on sex, race, religion, national origin, disability, or any other protected category. However, a settlement agreement can still prohibit employees from disclosing the amount that was paid to settle the claim. The new provision also applies to retaliation claims where someone has opposed allegedly unlawful conduct aimed at a protected characteristic. And the change applies to all settlement agreements entered into in connection with civil actions or administrative charges and, after January 1st of this year. Now, additionally, back in 2018, the legislature passed a law that prohibited employers from having non-disparagement agreements that precluded employees from disclosing unlawful acts in the workplace in exchange for a bonus or a raise or as a condition of continued employment. Well, in the wake of that law, there was some concern that employees would be confused with non-disparagement provisions as to exactly what they could and couldn't talk about. So we have a new law this year that now requires employers to use non-disparagement provisions to expressly include language informing employees that they are not precluded from talking about unlawful acts or allegedly unlawful acts in the workplace. So employers who are seeking to limit certain disclosures about workplace conditions have to include the following language in their settlement agreements. Nothing in this agreement restricts you from discussing or disclosing information about unlawful acts in the workplace, such as harassment or discrimination, or any other conduct that you believe to be unlawful. And the law says that you don't have to use this language verbatim, but you have to have some kind of language in your agreements that conveys this same sentiment. Notably, this language also has to be included in severance agreements to the extent that those agreements include some sort of confidentiality or non-disparagement provision that seek to prohibit the employee from discussing certain work-related events. That said, employers can still include general releases and waivers in their severance agreements, and they can also include language that prohibits employees from disclosing trade secrets and other confidential information that is unrelated to unlawful conduct in the workplace. And last but not least, the new law requires that additional provisions be included in severance agreements. More specifically, employees have to be notified that they have the right to consult with an attorney prior to signing, and they must be given a reasonable amount of time, but no less than 5 business days, to consider the agreement. So best practice tip here, make sure that you're reviewing your settlement agreements and your severance agreements to make sure that they are compliant with these new requirements. It's probably a good idea to have them reviewed by counsel just to make sure that they are going to be legally enforceable. And if you are using other types of NDAs or confidentiality agreements, you want to take a look at those as well, because you may need to make these updates to those agreements as well. All right, let's talk about workplace posters. This year, we have a new law that adds a short section to the labor code, simply stating that in any instance in which an employer is required to post a notice in the workplace, the employer can also email that notice to the employees. It doesn't really change the existing law because employers are still required to post in the workplace. It just also gives the option of employers, it gives employers the option to also send these notices via email. So bottom line here, continue physically posting the required notices at the job site, but you can also email these notices to employees, which probably makes sense if you have employees who are working remotely. FEHA record retention. Under the prior law, employers were required to maintain certain employment records for a period of 2 years. The new law that just went into effect requires employers to now retain these records for 4 years, which coincides with the recent extension of the statute of limitations for FEHA claims. And the records that are now subject to this 4-year retention period include employment applications, personnel records, and employment referral records. Additionally, if an employee files a complaint with the Department of Fair Employment and Housing, the employer has to preserve records until either the statute of limitations on those claims has run or until the complaint has been completely disposed of via the legal process. All right, so make sure you're keeping those records for at least 4 years. Criminal liability for theft of wages. And by the way, you guys, I know I'm flying through this because we have a lot to cover. I'm happy to chat more offline or answer questions at the end if you have specific questions about any of this. But I want to try to get through as much as possible. Criminal liability for theft of wages. So prior to this year, the California Labor Code specified that certain wage-related violations constituted a misdemeanor. However, to address concerns that some employers were intentionally keeping tips intended for employees, the legislature decided to add new potential criminal liability to the Labor Code for intentional wage theft. So Penal Code Section 487M now says that the intentional theft of wages in an amount greater than $950 for any one employee or $2,350 in the aggregate from 2 or more employees in any consecutive 12-month period may be punished as quote unquote grand theft. I'm sure none of you are intentionally trying to steal your employees' wages. I also don't foresee this being a high priority on the DA's enforcement list, but I thought I'd mention the new law anyways because it really serves as another good reason to audit your pay policies and practices. Make sure that you're continuing to train your managers on employees' wage and hour rights, and reinforcing the channels available for employees to raise concerns if they think they're not being paid properly. All right. Arbitration. We have a new law in California this year. As many of you know, arbitration has been a really hot button issue in California for several years, but we have a new law this year pertaining to arbitration fees. Back in 2019, California enacted a law requiring employers to pay arbitrator fees within 30 days of invoicing. Some companies were getting fee extensions without notifying plaintiffs' attorneys, which were upsetting the plaintiff's bar. So this year we have a new law that requires the arbitrator to send the arbitration invoice to all parties to the arbitration, and also requires the employer to pay arbitration fees immediately upon receipt of the invoice, unless the arbitration agreement specifies a longer time period for payment. So for those of you who are currently using arbitration agreements, you may want to consider including an explicit provision in your agreements that specifies a time for payment, or else you're going to be required to pay immediately. And this all brings us to the question of whether or not you should even be using arbitration agreements at this point. As many of you, I'm sure, know, there's been a lot of brouhaha in the California legislature and the court system over the past couple of years about arbitration agreements in the employment context. And a few years ago, we got AB 51, which essentially banned employers from mandating that employees sign arbitration agreements as a condition of employment. Well, AB 51 has wound its way through the court system, and we received a recent ruling from the Ninth Circuit a few months ago, which essentially upheld portions of AB 51. And we don't have time to get into the weeds on this, but the bottom line is that as of right now, it is risky for employers to mandate that new employees sign arbitration agreements as a condition of employment. For employees who have already signed arbitration agreements, you're probably okay. Those agreements are probably going to be enforceable. But you may want to consider moving forward, you may want to consider including language in your arbitration agreements, clarifying that consent to arbitration is voluntary rather than mandatory. And I think we're going to see AB 51 continue to wind its way through the court system. And I think we'll probably get some additional guidance on this issue in the future. But as of right now, you may want to consider making arbitration voluntary rather than mandatory. And I'm happy to talk offline with anyone who is currently using or thinking about continuing to use arbitration agreements. All right. I'm going to skip over warehouse quotas because it's a pretty, it has limited applicability, but it's a new law that applies to larger employers who have employees that work in warehouses. If any of you do have employees that work in warehouses, let's touch base offline. I'm happy to go through this with you, but I want to make sure that we have enough time to get to all of the COVID materials. We also have a couple of new industry-specific laws, which I'm not going to discuss in detail again, since they're probably not applicable to most of your businesses. I'll just say that AB 5 is continuing to rear its ugly head with the AB 5 exemptions to the ABC test, having been extended for licensed manicurists, newspaper carriers, and certain construction industry subcontractors. And aside from AB 5, if you have a business or your clients' businesses are in the construction, garment, janitorial, or transportation industries, let's touch base offline because there are a couple of other new California laws that are very specific to those industries, and I'm not going to take time here to discuss, but I'm happy to touch base offline, okay? So let's get to, I think we have a 7 or 8 minutes left. Let's talk about COVID. I know we're all sick of talking about COVID at this point, but we do have some important updates in this arena. The first is SB 93, which actually went into effect last April, but it provides certain rehire rights for employees in certain industries who have been laid off due to COVID. Now, this law specifically only applies to hotels, private clubs, event centers, airport hospitality operations, airport service providers, and businesses that provide building services to office, retail, and other commercial buildings. So again, because it has pretty limited applicability, I'm not going to go through all the requirements right now, but if you do have clients or you are in that industry, let's touch base offline, and I'm happy to walk you through all of the requirements of this law. Okay, let's talk about other COVID issues. Hopefully, most of you are aware by this point that California has reinstituted its mandatory mask mandate for all individuals, regardless of their vaccination status. This mandate is temporary. It's set to expire on February 15th. I think there's a chance that it will be extended for longer, depending on how the numbers on Omicron look. But as of right now, it is still set to expire on February 15th. And the mandate requires that all individuals wear a mask in indoor public spaces. Now, for any of you that have employees up in LA, you should be aware that LA has its own mask mandate that requires that employers provide their employees with KN95 masks or other surgical grade masks if those employees are working indoors around other employees or around members of the public. So again, it's just something to be aware of if you have clients or operations up in LA. Most of you have probably heard by now that there have been some changes to the isolation and quarantine guidelines for employees who either test positive with COVID or who have had a close contact with somebody who tests positive. These changes were initially promulgated by the CDC and then sort of adopted by the California Department of Public Health, as well as Cal OSHA. I'm not going to go through all of the requirements. They're all available on the Cal OSHA website, but basically there are different isolation and quarantine guidelines depending on the vaccination status of the individual, as well as whether or not the individual actually tests positive for COVID or has just been exposed to someone with COVID. But in many cases, employees are now potentially able to return to the office or return to work after 5 days instead of the previous 10 or 14 that we saw under other iterations of public health guidelines. So again, there's a nice chart on the Cal OSHA website that kind of lays this all out, or if you shoot me an email afterwards, I'm happy to point you in the right direction and send you the link. Just in the interest of time, I'm not going to go through it line by line, but it's fairly straightforward. Let's move on and talk about the amended Cal OSHA ETS. So Cal OSHA amended its emergency temporary standards as of January 14th. Part of the amendments were amending the isolation and quarantine guidelines that we just discussed, but there were a couple of other things to note. There were a couple of changes to definitions. For example, the term face coverings was clarified to require that the fabric not allow light to pass through when held up to a light source. And the guidance now says that masks must fit snugly over the nose, mouth, and chin with no large gaps on the outside of the face. And the ETS now say that if an individual can't wear a face covering because of a medical disability or condition, that they should wear some sort of non-restrictive alternative, such as a face shield with a drape. And if they can't wear that non-restrictive alternative, then they must social distance and either be fully vaccinated or be tested at least weekly. Another change to the ETS states that if an employer conducts COVID-19 screenings indoors in the workplace, that face coverings have to be worn by both the screener as well as the employee, regardless of the vaccination status of both of them. And with respect to post-exposure testing, the amendments now require that the post-exposure testing be made available to asymptomatic and fully vaccinated employees, whereas previously employers were not required to provide that testing for fully vaccinated employees unless they experienced symptoms. So if you haven't already done so, I encourage you to look at the amended ETS on Cal OSHA's website, just to make sure your organization is already in compliance. Again, there aren't any huge changes. The biggest changes really are the changes to the isolation and quarantine guidelines. And I'm happy to chat further offline with anybody that has questions about any of that. Moving right along to the Biden administration's vaccine mandate for larger employers with more than 100 employees. Over the past couple of weeks, that mandate or attempted mandate has essentially become dead in the water. The U.S. Supreme Court stayed enforcement of the federal OSHA's vaccine and testing ETS, which would have required larger employers to mandate vaccination or adopt a policy requiring non-vaccinated employees to undergo weekly testing. So the U.S. Supreme Court said, hold on, no, we're not going to do that. And since that time, both the Biden administration and federal OSHA have said, okay, we're not going to, continue to pursue that. So for all intents and purposes, that mandate, I think, is dead in the water, at least for the time being. But that said, there's nothing currently that prohibits California employers from deciding to mandate vaccination for their employees, subject to certain exemptions for medical issues and religious beliefs. Also important to note that the Supreme Court upheld the federal vaccine mandate for medical facilities that accept Medicare or Medicaid payments. So if you're in the healthcare industry or you have clients in the healthcare industry, you just want to make sure that you are aware of that nuance. And again, the Supreme Court did uphold the vaccine mandate for the healthcare industry. The next topic is really breaking news. It's something that's just developed in the last day or so. It looks like here in California, we're going to see a return of supplemental COVID paid sick leave. From what I've heard, it sounds like Governor Newsom and the California legislature have reached a deal to re-implement this supplemental COVID paid sick leave for companies with 26 or more employees. The legislature has not actually been signed into law yet, so don't take what I'm saying as gospel. But based on what I've heard and what I've read, it sounds like employees are going to be entitled to up to an additional 2 weeks of paid time off for COVID-related purposes. It sounds like there's going to be a testing component whereby employees will only be entitled to take that second week off if they or a family member can show proof of a positive test. And it sounds like this is going to be in effect through September 30th of this year and retroactive to January 1st of this year. So again, don't take what I'm saying as gospel, because I haven't actually seen anything in writing, but I'm definitely going to be posting updates on my LinkedIn page. So if you'd like to connect with me on LinkedIn, please do, and I'll make sure to post updates there, or again, happy to chat offline. All right, so those are the COVID updates I have for you. Before we wrap up, I just want to mention two other important things. The first is an important wage and hour issue that may impact some of your non-exempt employees. There was a case that came out last year called Donahue versus AMN Services. And in that case, the California Supreme Court confirmed that employers cannot round employee time punches in the meal period context. So for example, if an employee clocks in after 28 minutes from lunch, then the employer cannot round that meal period to 30 minutes. And the employee should be getting a meal break penalty if they clocked back in after 28 minutes involuntarily. So if you're in the habit, your clients are in the habit of rounding meal periods, that's definitely something to stop doing right now. If any of you are still in the habit or know people in the habit of just entering 30 minutes for all employee meal periods and aren't actually having employees manually clock in and clock out for meal periods, that's also something to stop, because the California Supreme Court has also made that clear over the past couple of years that that's a big no-no as well. And I've seen and I've litigated many wage and hour class actions and PAGA cases related to meal period punches. So again, audit your policies and practices and make sure that you're in compliance on that, okay? And the last thing I want to quickly mention, this is really more of a reminder than any sort of legal update, is California harassment prevention training. Many of you probably trained your employees in 2020 to come into compliance with the new law, the expanded law that requires all companies with 5 or more employees to provide that training. The initial compliance deadline was January 1st of 2021. So a lot of companies did their initial training during 2020. And if that's when you did your training, your employees have to be retrained again during 2022. So that's just something to keep on your radar on top of everything else you're trying to juggle and stay up to date on. Make sure that you are up to date on your harassment training. I offer harassment prevention training. I have other resources that I can connect you with if you need resources for that. So feel free to reach out. And I think that's all I have. And I think I almost made it in my 30-minute allotted window. I know I covered a ton of information and I apologize, but I wanted to get through as much as possible. But again, I'm happy to chat offline or answer questions. And please feel free to contact me and use me as a resource, because I know that the California employment law world is challenging to navigate. So thank you so much for your time and for being here. And I hope you all have a very happy and prosperous 2022.
Jenna, before we let you go, just real quick, that's great. You kept us on time. I wanted to make sure that if anybody has any questions, feel free to put them in chat, or if you think it's easier, just raise your hand with the reactions. We do have a little bit of time for that. The other thing that I would say, we've got some stuff that is from the state. I'm going to go ahead and share my screen for a second, another screen. And if I can find it, let's see, that is show all windows. The state has put together something called saferatwork.ca.gov, which is a new site that is available for help in terms of understanding COVID restrictions or requirements, and especially provides both not only the legal requirements, but guidance that's coming from public health officials in the county or in the counties that you work with. And so this is a resource that you can take advantage of. Again, saferatwork.ca.gov, and it's a joint project of Cal OSHA, Cal Department of Labor, and a couple other state agencies that provide online resources when it gets to COVID. And so one of the things that the state asked SDNEDC to do was to promote and get the word out about that resource. So ergo, what we are doing today. But I'll go ahead and.
I'm aware of that, Eric. That's a great resource.
Yeah, no, it should be excellent. So let's see. I'm going to go back to the normal and stop sharing. And again, if we have any questions, We have a comment in chat, and again, that CMPC, which is a great resource for manufacturing, and again, that they provide complimentary harassment training to California manufacturers. And so CMPC, if you're interested, I know, I think it's Amanda that's participating from CMPC. Amanda, if you put your information in the chat, that'll be both available to folks and then as well on the recording. So a service which is great that's out there. Before we wrap up, one last call. Any questions on what's going on? Again, I think Jenna referred to it. The legislature wasn't as busy as usual, so maybe 2022 is like a little bit of a respite. But as we navigate through the COVID world, I'm sure it's keeping us all busy in terms of our employees and working through. Well, with that, we'll then wrap up. I do want to bring a couple of things to your attention. We have 2 lunch and learns that are scheduled end of next month. We are hoping to hear from folks at Amazon. They have offered to provide a webinar that's focused on some of their things that are doing up in North County, last mile distribution. We hope to be back at the Green Dragon, so be on the lookout for that. And then at the end of March, again at the Green Dragon in Carlsbad, that last Wednesday, Latham and Watkins is going to provide an update for those that are involved with whether it is development or other activities that might touch upon the California Environmental Quality Act, CEQA. So that is always an area of law with a tremendous amount of changes year over year. And so Latham is going to be providing a CEQA update if that's of interest to you or other people in your organizations. Again, thank you for logging on. We'll be sending out a link to this as a YouTube should you want to review. And then as well, we'll send out a copy of the slide deck in case you want to review. Jenna, thanks again so much for making yourself available for this. Again, contact information for Jenna is in the slide deck. So if you have specific questions, I know she'd be happy to talk with you and figure out how to aid and help your organization. Have a great rest of your Wednesday, I guess it is. The week is flying by fast. So a great rest of your Wednesday. And again, thanks so much for joining us today.
Thank you.